A warm welcome to all our alumni. I think 10 people are already in the conference and more, I'm sure, will join soon. We will be, waiting for a few minutes so that all of us, we give an opportunity for everyone to join. And a warm welcome and thank you again for, despite being a working, week today and a Wednesday, thank you for everyone for, taking time out of your busy schedule and coming and joining today. And Dana is very, privileged to have Nishat, who is the Wall Street group here. And the topic that we chose was very, very, I think, is very relevant to our lives. It is about, understanding about wills and trust and what, as physicians, we are supposed to do. We are very good, in terms of our clinical practice and medicine, but we are very poor when it comes to financials, plans for us or for our beloved ones. And without wasting much ado, I will request Taruj to, host this conference and, continue. I'm available for any questions, along with Taruj at end of the seminar. And I just want to let you, tell you on the onset that this seminar is going to be recorded for the purposes of, helping others who have not attended it, and also, for us to go back and review it at a later time and to try to understand better if we missed something. Taruj, thank you. You can take over and welcome Nishat.
Thank you. Thank you very much for having me.
Thank you, Dr. Moizuddin, for that introduction. Can you guys hear me?
Yes, perfect.
Hi, good evening, everyone. So welcome to DAANA's educational webinar about estate planning and tax saving strategies for physicians. I'll be hosting this with Dr. Moizuddin, and this is an educational webinar, and we request all the attendees to consult with their financial advisors and attorneys before they take any action, for any personal advice. In this webinar, what we have done is we've put together a few frequently asked questions from our previous webinars, and we want to make it an interactive session, not a boring presentation. So I'll be asking questions to Syed, and we'll make it interactive, and he'll answer the questions. You can also ask your questions. You can either raise your hand or you can put it in the chat box, and then we'll address your questions. Just a brief introduction. Syed is a fiduciary financial advisor, and he's a partner at the Wall Street Alliance Group. His articles and interviews about asset protection and common financial mistakes by physicians are published in MedPage Today and Medscape. He's regularly quoted and interviewed in media outlets like Forbes, Kevin MD, US News, Investment News, and Yahoo Finance. Syed, thank you so much for coming today.
Thank you again, Dr. Ali and Dr. Moizuddin, to invite us. I really appreciate what you do for DAANA. It is a thankless job. Obviously, you're doing it at night, but I really appreciate it. You're doing it for the audience.
Thank you. Thank you so much.
Yep.
So before we start, I have a tax planning question. Do you have any advice for tax saving before the deadline that's coming up, March 15th?
Yeah, it's a great question. So I think for the audience, before we talk about estate planning, I think it's going to be a good way to start because everyone hate paying taxes. So a few of the laws I think that the physicians may be aware of that before March 15, which is for the corporation, and April 15 for individual tax filing deadline to try to incorporate in your tax planning. So number one, if you're self-employed and if you have your own corporation, few states like Illinois, Virginia, Dr. Ali, where you live in, New York, New Jersey, they have adopted a law that if you owe any state tax, like when Trump became president, the maximum deduction for state, local, and property tax is $10,000 when Donald Trump was a president, and it's still continuing. But Virginia, Illinois, New York, for the last couple of years, adopted a law that if you pay the same state tax from the corporation, you get the full write-off federally. Again, very powerful. It's not automatic. So if you owe any state tax, don't pay individually, pay from the corporation. That's number one. Number two, a lot of physicians in DAANA or other organizations are self-employed. So if you're self-employed, before March 15th or April 15th deadline, depending on the type of your tax situation, you are allowed to open up a solo 401k or defined benefit plan. Previously, the law was by December of that particular year, you had to adopt it. By now, the law changed before the tax filing deadline. If you are a solo or self-employed physician, you can open up a defined benefit or your own 401k for your practice. You still can get a full write-off. Just to give an idea, in defined benefit at the age of 52, you can contribute almost $200,000. The money is completely tax write-off. Also, you can open up an IRA account. IRA account is just an individual name, about $7,000 you can contribute by April 15th, and this money is also write-off as well. So again, there's not much you can do, but again, before April 15 deadline, some of the ideas there. Backdoor Roth IRA. A lot of physicians, Dr. Ali and Dr. Moizuddin, didn't qualify for a Roth IRA because the income is very high. But you do qualify something called a backdoor Roth IRA. In a backdoor Roth IRA, you open up a post-tax IRA account, you open up a Roth IRA account, you put the money into post-tax, transfer the money immediately to a Roth IRA. There's no income restriction there. There's no taxes there because you're converting the money immediately. So again, backdoor Roth IRA makes a lot of sense. For previous year, before April 15, you can contribute husband, wife, and convert the money. A lot of physicians, especially within our community, they invest into real estate. Like commercial real estate, residential real estate for rental income purposes. It's quite common. If you have rental income before the tax filing deadline, speak to your CPA or financial advisor about cost segregation. It is like that early when you invest into real estate, there's a depreciation schedule. Like every year there's a depreciation, you can get to write off from the rental income. But the schedule is up to you, meaning the 29-year depreciation, if you want to bring it down to, let's say, 5 years, you can do it. This study is called cost segregation, but you have to do it before the tax filing deadline. If you have a lot of rental income, speak to your CPA or financial advisor before the tax filing deadline if I want to do the advanced depreciation or not. The idea is you're in a high tax bracket, don't pay income tax, the cost basis goes down, but again, it does makes a lot of sense if you want to hold the property for long term. And lastly, buying a bigger vehicle. So it is too late for last year, but I want to put it out there because when you buy a car, if it weigh more than 6,000 pounds and you have your own corporation, you can write off the full purchase price of the car as of last year from your business. It's very powerful. Usually it's like an installment, but right now because of accelerated depreciation, you can get to write off the full purchase price of the car from the business last year. This year, it's 80% of the car you can get to write off. And after this year is expiring. So again, if you need a bigger vehicle, I'm not saying go ahead and buy a Maserati under the name of the business, but what I'm saying that if you need a bigger car, this is a good year to do so because you can get to write off the full purchase price of the car. So again, it's about 5 important, tax planning tips. There are more into it, but these are some of the things I think is important to sit down with your CPA and discuss about it.
Thank you, Syed. I know we have a lot of members who like fancy cars, so that's really good advice.
Absolutely.
So from next year, it's going to be 80%?
Yeah, from next year, actually, it's going away. It's not
Oh.
it's not 80% anymore, 100% anymore. The extra depreciation is expiring. This year, 2024 is 80%.
Okay.
So that's why it's a if you ever need a bigger car, like Tesla Model X qualify for it.
Yeah.
So it's a good time to buy it.
So you buy it. Okay.
Yeah.
Well, great. So like we said, we're going to do this as a Q&A session, so it's interactive.
Sure.
So I'm going to ask the question.
Sure.
So Syed, without sounding like a lawyer and making it very complicated, can you, in very simple, plain English, explain to us what are the components of estate planning?
Yeah, I think the whole estate planning is the most important but most neglected aspect of financial planning. It's a real example that during COVID time, in our practice, 80% of our clients are physicians. So they get the hit during COVID time. And one of my best client passed away during COVID. I cannot imagine this client not having will and trust. Just to give you an idea, this client of mine, best client, who passed away, if he didn't have a simple will or trust, something as simple as the custody of the children would be decided by the US government. And his wife, she was from Pakistan and didn't speak that much English, the whole asset would have been gone through something called a probate process. But the client has the foresightedness to get the will and trust done, but at least there's no way to measure his loss. But having a proper estate planning allow them to focus on his health while he was seriously sick. So I think it's very important to get for physician community to get some basic estate planning done. Now, estate planning doesn't need to be complicated. The first important thing you should have to do is just get the basic will done. Just a will, one will for you, one for your spouse. It just dictates what happens if anything happens to both of you. So, in this way, the court doesn't decide is according to your wishes. Living will is also important. That's the second I'm hovering my mouse. Living will means like power of attorney. If you're unable to make a decision, then your wife or vice versa should be able to make a decision about your finances. Health proxy as a physician, that's also important, life and death situation that you should get it done. So that's called living will, this too. And last component of it is called trust. Now, trust is optional. Some people say trust is not needed, but if you just have a will, it's not like tomorrow your family get the money if you pass away. What happened that the wife or your beneficiary would have to check the copy of the will, your death certificate get to the court. New York, Virginia, things are getting easy, but Texas, Illinois, it takes a long time, probate process. So that's why for physician, depending on your net worth and how old you are, we recommend to create a revocable trust as well. Again, 3 major components: will, living will, which is health proxy power of attorney, and a revocable trust. These are the 3 major important components of a basic structure of estate planning. Hopefully I didn't confuse too much, to try to get it done as soon as you can.
I see. So what I'm hearing is maybe a will is not enough. You also need a trust. Is that right?
Yeah. So depending on your net worth. So it's not like, like at the beginning you said, you have to speak to your financial advisor. So if your net worth, I'm saying just a house or a retirement account, just having a will and making the children as a beneficiary should be good enough. But most of the physicians, I deal with are a little bit high net worth. They do have multiple real estates, they own properties out of states. So it becomes complicated. So that's why we recommend for physicians, since they're high net worth, get a trust as well. There are 3 benefits of trust. Number 1 is avoid probate, like I mentioned. Number 2 is think logically. If tomorrow you pass away, your children inherit the money, they grow older and get married and get into a divorce, the asset becomes half. But if you give the money through a trust and the children inherits it, all the assets are protected from divorce. It's very powerful though, again. So number 2 benefit is divorce protection, asset protection for the children, not for you, for the children. And number 3 important thing is the step up in cost basis. It's a little technical, but I think I can explain. So let's say you bought Apple at $100 per share and stock right now is $200. If you pass away and your beneficiary inherit the Apple shares from the trust, they get a step up, which is $200, not $100. So the difference of 100 to 200, $100, they get a step up in cost basis. So I think these are the 3 major reasons we recommend to create a revocable trust as well, is because most physicians, according to our knowledge, are high net worth.
So what I'm hearing is for the children, there are tax benefits to this, right?
Absolutely, for children, correct.
Okay. And what are some of the common mistakes that physicians make when they're creating a will or a trust?
Yeah, so 3 major mistakes we see all the time. So number 1 mistakes we see is that if they're to pass away, they put their children's name for the assets. Let's say I have my 2 sons, Ayan and Noah. If I die, they get 50-50 under their name. But again, like I mentioned, they become older and they get into a marriage or divorce or lawsuit, all that just becomes half. So we recommend that when you create a will and trust, put a provision there. The children will not get money on their own hand. What will happen, they will create their own trust and transfer money out. So it's a separate asset. So we always recommend not to give under their name. It's called lifetime trust for the children, then transfer money, number 1. Number 2, we see major mistakes people make is they create the trust, the will, but never fund it. What I mean by funding is like if you create like a revocable trust, a private document, the house should be moved under the name of the trust. The brokerage account should be moved under the name of the trust. If you don't move it, it's a fancy document collecting dust. And so if you pass away, everything goes through probate. So make sure you move everything under the name of the trust. And number three, we see people make mistakes, like they create the will and trust. They move different states for job, or they become older, especially older people. They move from Virginia to, let's say, to Florida. Florida has their own statute. Virginia has their own statute. Make sure you update it as well. And every 4 or 5 years, the trust provisions gets updated, the tax law updated. So make sure you update as well. It's not a one-time thing. Every 5 years, you should always revisit it. So these are the three things. Don't give it under the name of the children, not funding the trust. And number three is when you move to a different state, make sure you have the latest provisions there as well.
Thank you. Syed, you kept mentioning probate. Can you just explain what that is?
Yeah, so probate, basically, it is a legal procedure by the state where you have the residency, and if you pass away, so what happened that the children or your beneficiaries don't get the money the next day. So what happened that there's a legal process involved into it. The legal process is in New York. I need the copy of the death certificate, and I need to fill out some forms, and I have to send it to the county I used to live in. My children needs to do it. And then the county get all this document, do the validation process, and then send the check according to my will or my wishes. This is a process. This process is called probate. So depending on the state you live in and depending how complicated is your assets, it may take longer. And to process all of it, there's such fees involved into it from the court. And the fees could be very expensive depending on where your assets are held at. So we are recommending the best thing to do if you have multiple assets to create a trust as well. A trust is a private document. You create it, you fund it. So in this way, there's no probate, nothing whatsoever, no headache, and you can get it done while you're alive.
Thank you. That's great. So if someone has a child with special needs, what are the considerations? What are the special considerations for estate planning?
Yeah, so if you have a child with special need like autism or some physical disability, one thing to remember, remember this conversation can be a webinar of its own, but I just want to touch base real quick because a lot of physicians are not aware of it. A child cannot have more than $2,000 under the child's name. If the child has more than $2,000, all the government benefit goes away. So what you do at that time, you open up a special need trust. It's a type of trust. You open it and you can fund a special need trust. For example, cash, real estate, for the benefit of the children. The advantage of it, all the government benefits doesn't count, in terms of like the child's assets, and it is part of the special need trust. So I think it's extremely advantageous to have the special need trust, and the child can collect the SSDI, and you're able to open to ABLE account as well for the child. But the bottom line I'm trying to explain that if you have a child with special need, it's very important not to have anything more than $2,000 under the child's name. Some state planning needs to be done called special need trust.
Thank you. How often should you update the will and trust document? And typically, how much does it cost for someone to do this?
Yeah, I think it's one of the a topic, people think will and trust is very expensive. It's not. Usually every 5 years, it's a good time to revisit it. But every 5 years, if you haven't accumulated much of assets, if you don't have many more children, or don't want to update the trustee, all good. But 5 years is a good time to take a look. But typically every 7 years, the law change and state law change. We see a pattern. So we want to update the provisions there. How much does it cost? A will, power of attorney, held proxy costs about $800. Again, will, power of attorney, held proxy costs about $800. Trust is a little expensive. That costs additional $3,000 on top of it. So altogether, between $3,500 to $4,000, you can get the complete estate planning done. That's without the filing of the deed and everything. So a lawyer usually we see charge between $3,500 to $4,000 to get the will, power of attorney, held proxy, and a revocable trust done.
Thank you. That's very helpful. So before we move to the next topic, I'm going to take some questions. I'm looking at the chat box. So there's a question from Dr. Ehtisham Syed. He asks, Will a trust protect your assets from any malpractice judgment?
No, so this webinar is mainly about estate planning. So revocable trust is part of your state. There's no asset protection whatsoever. So that's a different topic. We can talk about it like LLC, domestic asset protection trust. So today we're only talking about estate planning, how to avoid probate, and that's it. But revocable trust have no asset protection.
Okay. So Dr. Shaista Safdar is asking if the property is in a trust, is it protected in case you get sued as a physician?
Yeah. So the question is that if the assets are into a revocable trust, so there are two types of trusts, just to give you an idea to the audience. One is called revocable trust. One is called irrevocable trust. When do you use it? We are so far, if you're seeing, I'm keep talking about revocable, meaning you open it, it's a very basic, you can change it anytime you want, things are in your control. All you're doing is avoiding probate. Just in case, I'm going to pick Dr. Moizuddin. Let's say, I want to gift my children, and I want to protect my asset. Do you have any sorts of trust there? That is called irrevocable trust. You do it for gifting to the children, but the benefit of irrevocable trust is if you gift it, all the assets have elements of asset protection, but you lose control over it. So that's again irrevocable. So the first step should be revocable trust. Once you've done it, your net worth is very significant. What I mean by significant, more than 15 million. You can think about irrevocable trust because remember, you lose control over it. And then if you put money into an irrevocable trust, the assets are protected.
I see. And is it true that if you have a revocable trust, once you pass away, it becomes irrevocable?
Yes, a very good point. So what happened, the revocable trust after you pass away by law becomes irrevocable by law. So that's why no one can change it. So that's why it is asset protection for the beneficiaries, for your children, because that becoming irrevocable at that time. But you can also create irrevocable while you're alive for gifting purpose for the children as well.
I see. Great. There's a question from Dr. Sharif Zahuruddin. He's asking, is the trust only for US fixed assets, or do international fixed assets can be included here in the US?
Yeah, unfortunately, the will and trust doesn't work overseas. They have their own jurisdiction. So whatever we can fund it here, you can, put all of it, but it just simply doesn't work practicality. So let's say, for example, I'm from Dhaka. My father had to do his own will. India, that you have to do your own will. So that law prevails there.
I see. A question from Dr. Fawad Khan. A step-up cost basis takes place in ordinary inheritance as a beneficiary. How is it different with using a trust?
Yeah, so step-up cost basis takes place in ordinary inheritance as well. Absolutely, you're right. You still get it, but it is cleaner in a revocable trust. That's all I'm saying. So, for example, if you pass away, your children inherited under individual name, yeah, fine. If you have no will, if you have nothing, it is muddy. But if you have a revocable trust, if you have a will, yes, it is very clean. And the child, basically, if you do it properly, create their own trust, get a step-up basis, and there's a new cost basis for a tax purpose. So it's much cleaner.
Okay. There's a question from Dr. Basha. How do you move your brokerage accounts into a trust?
Yeah, so depending on which company you have with, I'm just giving you an example, Fidelity, our custodian NFS, which is Fidelity. If you have an account with them, we call them, we just open up a revocable trust. Usually they ask for a copy of the trust. You get it from an attorney, you move it. It's usually under the name of your social security because remember, it's revocable, not irrevocable. And then you move all the positions from a joint or individual to the trust as it is, no selling, nothing. That's it. Some brokerage company create a big issue, big fuss about it. One option could be you can open up a TOD brokerage account. TOD means transfer on death, and make the beneficiary your revocable trust if moving everything to revocable trust is a problem. So these are the two solutions.
Another question from Dr. Atika Khan. Can a person who has a SEP IRA through corporation have backdoor Roth also through W-2?
Yeah, so basically the question is that through your own corporation, you have a SEP IRA, and you through W-2, whatever income you're having as an individual name, can you open up a backdoor Roth IRA like I mentioned? You can, but there's a problem though. The problem is, in order for the backdoor Roth IRA work, you cannot have an IRA account existence. Like this Dr. Khan, she has a SEP IRA. SEP IRA is treated as a regular IRA. There's a problem. Problem is that let's say you have a SEP IRA account open. Now you're doing a backdoor Roth IRA strategy, like you open up an individual IRA, open up a Roth IRA, you convert it, you put 6,000, I'm giving example, and you convert it to a Roth IRA. The whole 6,000 should be tax free, like no taxes in it because you immediately converted it. But the problem, you have you have a SEP IRA account open, and if you have a balance there, there's something called exclusion ratio come into play. It doesn't work. It becomes complicated. So that's why in order for a backdoor Roth IRA to work, you should not have a SEP IRA or some sort of existing IRA. You should open up a brand new, nothing open. The solution to this situation for Dr. Khan, if she have a SEP IRA, she can move it to a 401k through work if she have any. So there's no SEP IRA, nothing in the market in open. So she can open up an individual IRA, a Roth IRA, do this strategy there. Hope it makes sense.
Let's see. Here's a question. When a trust is created, do you need to register it somewhere, or you just get it notarized and is that enough?
Yeah, once you create a trust, there is no registration anywhere. But remember, the deed of the house needs to be changed. So that is technically under the name of the trust. So this is a private document. You keep it, you notarize it, some portion of it, but the title needs to be changed of certain assets.
I see. Let's see. I think we answered all the questions. If there's any other questions, please keep them coming. I'm gonna go to the next section. So next question, Syed, is what is the difference in Islamic will and trust from just a regular?
Yeah, so people think that the Islamic will trust is like a huge difference in terms of the provisions and the state law. I mean, we have seen, we have worked intensively with a lot of attorney and a lot of our clients who want Sharia compliance will and trust. The actual state law provisions, that's not something that is pretty much the same. The main issue is the distribution that make the difference, Islamic or non-Islamic. There are a few things we see it is called a declaration of faith. So these are called intent letter in the will, a separate section you can put it. All the debt should be paid off. The Islamic rules and inheritance you need to be implemented, and Islamic funeral and burial service. You just put it there into the instruction section. Now, when it comes to distribution by FCNA, which is Fiqh Council of North America, or you can go to Saturna, these kind of websites out there. They have given a very good suggestion how the distribution is going to be. Like, for example, if the wife passed away, husband passed away, wife get 1/8 of the assets. Now, there's some planning needs to be done. And this is something subject for interpretation. What I mean by subject for interpretation, some of my clients want Islamic distribution after husband, wife both pass away. There's one rule of thought out there. Some people say, no, I just want to exactly follow the distribution of whatever's written there. One solution could be you open two trusts, one trust for you, one trust for your spouse. I understand that the spouse is not going to get all of your money, but one option could be you give more assets to her in her trust. So in this way, that if you were to pass away, she's not only getting 1/8, already some of the assets are under her name. So it is not the provision, it's the distribution and planning that makes it changes in Islamic will and trust. The cost is almost the same, just like anything. It's a distribution that makes the huge difference. So that's why some planning just needs to be done. And any experienced estate planning attorney, can take a look at Islamic distribution, and based off of that can create a Sharia compliance will and trust for you.
And these are things that if people want to use your services, you can help them?
Absolutely. We have an attorney we work with. We should be able to collaborate all of this for you and take care of that.
Okay, great. Next question is, so in the US, it seems like you always pay taxes. Even when you die, you have to pay taxes. So can you just talk to us about what is estate tax or death tax? How does that work?
Yeah. So in America, unfortunately, you pay tax while you're alive, you pay tax after you pass away. But the good thing is the net worth as of right now needs to be more than 24 million. But there's one problem, is expiring next year. In 2025 is coming down to 12 million. Husband, wife both pass away. So how does it work? Husband, wife both pass away. The net worth is more than $12 million. This law expires from 24 to 12 million next year. Let's say your net worth is 20 million. You have to worry about anything more than 12 million, 20 minus 12, which is 8 million, 50% state tax. And some state has their own state tax as well. For example, Illinois, New York, you have to worry about as well. So unfortunately, it is there, the state tax in America. But as of right now, nothing more than, you have to be more than 24. But just in case if your net worth is significant, some planning needs to be done because it's changing next year.
Okay. So for people who are high net worth, not like me, but some of our physician friends on the West Coast or in Dallas, Texas. So for them, what are the strategies to lower your estate taxes before year end?
Yeah, a few things, like if your net worth is substantial. Now, one option could be, remember, we spoke about irrevocable trust. In irrevocable trust, you can gift it. Anything, assets more than, let's say if your net worth is 20 million, you think the law will change back to 12 million, one option could be $8 million gifted to the children in an irrevocable trust. The benefit is once you gift it, the money is out of your state, it grows state tax free before the law change. On top of it, every year from this year, about $18,000 you can gift it to the children. This money is out of your state. So if you have 3 children, 18,000 times 3, about 54,000. This money is out of your state per parent, per child. So husband, wife together, a significant amount money can be out of your state. Third one, life insurance policy. If you are not that strict, in terms of like Islamic investment, if you're okay with life insurance. So one option could be, you can remember the state taxes is due only after both husband and wife pass away. You can buy like a cheap second to die life insurance policy, and that can take care of that. If you have a life insurance policy, one option could be you can create a life insurance trust and move the money to a life insurance trust, and the money is out of your state. And then if you are, one more thing I just want to talk about, but I'm not going to go detail. If you're really charity minded, a lot of physicians are charity minded. And if your net worth is substantial, one option could be, which I'm not going to cover too detail, you can open up like a charitable lead trust or a foundation. The way the process works, after you pass away, any net worth more than, let's say, you can put in 12 million, 8 million can go to some sort of charitable trust. You can design in such a way like your children are the trustee of the trust. It can go for generation and eventually can go back to your family tax free. So again, that could be a separate webinar, we can have it, but I just want to have the punchline in front of the audience so they can get familiar a little bit, what are the strategies out there.
Right. So here's a compliment for someone who's high net worth from the West Coast. Dr. Khutub Khan says you're a very knowledgeable person, mashallah.
Thank
And
you.
he has a question. Can you help someone in California, or are there certain states where you work?
No, so as a financial advisor, I'm registered all the states, but the attorneys we work with can help all the clients anywhere within the United States.
Great. All right. Can you give me an example of SLAT, or Spousal Lifetime Access Trust, that you mentioned?
Yeah, so just in case, like I just want to, so far, in the beginning, we talked about revocable trust. I just want to touch base again because physicians do ask about, I do want to gift it to my children. What do I do? So, so you can think about if you really want to gift it, depending on your net worth, SLAT, SLAT, Spousal Lifetime Access Trust. It is an irrevocable trust. But what happened that you can gift the money to the children as long as the spouse is alive, you do have access to it. Again, usual irrevocable trust, you don't have any control, but this one, SLAT, is a type of irrevocable trust. As long as one of the spouse is alive, you do have access to it. How does it work? So let's say you create a SLAT, you put the money, you cannot take the money, but SLAT allows your wife to take the money and give it to you. So this is typically how it works. If your net worth is significant, you want to gift it, a good way of thinking about is SLAT, Spousal Lifetime Access Trust, is an irrevocable. You do have access to it indirectly to your spouse. I just want to give you one example, and hopefully it is not that complicated. So let's say your net worth is 15 million. and you're earning about $200,000 every year, you have 10 years, 7% growth happen, and you have a $4 million life insurance policy. I'm just giving an example for a client like 15 million. It's common, scenario. We see it. 15 million net worth, 200,000 you're earning every year, 10 years, 7% growth happen of this net worth. The net worth does become 32 million. According to the current law, 7 million is still state taxes due, because remember, anything more than 22 million state taxes are due. If the law changed in 2025, which is next year, 12 million, the government will take it away. Very, very powerful. One simple solution, I'm just showing you how it may work in state planning point of view. So to get a gist of it, from this 15 million, you can just get about 11 million right now to the children. You can think, hey, 4 million is enough for me to have a good life because I'm still earning money. This 11 million is out of your state. You move the life insurance to a life insurance trust as well. Every year you still earn 200,000. 10 years happen, 7% growth happen, the value becomes 10 million. No state taxes due according to the current law, and even the law changed back. Since a lot of money you moved out of your state, I'm talking about in 2025 also there's no state taxes. So we're talking about almost $12 million taxes that you can save. So again, we can play with the number, any financial advisor, and say, okay, what the projection looks like, how much is your net worth, how much you're saving, and can give you suggestion whether an irrevocable trust, like someone asked about asset protection, if you want to do it, it is a one way of asset protection plus giving to your children as well. So hopefully I didn't confuse too much. So just want to give you a gist of it, how irrevocable trust may work.
Great. So another question on estate planning. What is Secure Act 2.0 and how does that affect estate planning?
Yeah, so Secure Act, this is something I think is a new law, but a physician should be aware of it. I just want to tell you, not give a full solution, because it is just the most important thing to just understand. So basically what happened that if you have a retirement account like 401k or IRA account, and if you pass away, your children inherit the money. Previously, what it used to happen, they have their whole life to slowly take the money out. It's called RMD, required minimum distribution. Again, let me repeat. If you have a retirement account, you pass away, your children inherit the money, they have their whole life to slowly take the money out. So they don't pay too much taxes. Last year, Secure Act, SECURE, passed. It's a change we should be all aware of. If you have a huge 401k plan, retirement account, which most physicians do, they work for the hospital, they have 401k. You pass away, husband, wife both pass away. Now children inherit the money, and children is over 21. They have 10 years to exhaust all the money, meaning they have to take everything out within 10 years. You might be thinking, what's the big deal? It is a big deal because previously they had their whole life, but now within 10 years, they have to take everything out. It's a lot of taxes they have to pay. So we're not going to talk about the solution for it, but this is something to just think about it, that the reason I'm saying it, don't put too much money into the 401k, because you might be thinking you're saving money in taxes, but your children will pay eventually. It's just like, we have one view of thinking. So maybe some other strategies needs to be done. So this is why it is important to speak to a qualified financial advisor, your CPA. Hey, they passed the Secure Act. I have a huge money. What do I do to save money in taxes? So I just want to point out there, think about it. We can talk more one-on-one depending on your situation.
I see. So there's one more question which we forgot to ask. Some DAANA members might not be US citizens. So are there any special considerations for estate planning?
Yeah, one quick point out there that a lot of our physicians are non-US citizen. So the way the process works, if you pass away, and my wife is a US citizen, she inherits the money all state tax free, nothing to worry. But that's not the case for non-US citizen. There's a limit for it. After that limit, taxes are due. So I want to go back to this slide real quick for the audience to see it. If you are a non-US citizen, I'm hovering my mouse called QDOT. QDOT. It's a qualified domestic a trust. So it's just a provision. You just have to put it there. It's QDOT. What it does is basically um, tells that if you pass away and if your spouse is a non-citizen, the money will stay into this trust. You can do it in such a way that the wife, after she becomes U.S. citizen, only she have access to it. And there are more to it, but the bottom line is that if the husband wife non-U.S. citizen, not everything goes to the spouse tax-free. Q dot provision is important to put in consideration for estate planning as well.
Great. So there's another question about foreign nationals. Can foreign nationals or citizens be trustee on a US-based trust?
Yeah, there's no restriction to it, but what I'm saying, it doesn't work in practicality. I mean, how are you going to get visa? How are you going to come to America? You can do all of it, but ideally we want someone local within US, I'm saying, if it's possible. It's just like I had a client pass away that they put like in Pakistan, and we were never going to get a hold of them. So it does happen a lot. But if the person is close knit, can travel very easily, it may work, but in practicality, it becomes very hard.
See. I think there's someone who has their hand raised. I don't know if they want to ask a live question. Is that possible, Syed, or do you see that?
Yeah, let me see if I can allow. Johan, can you allow? I'm not sure. So yeah.
Yes, I just allow Dr. Kram to ask the question. So he has to unmute himself and then
Akram, do you want to ask a question live? You can speak, or if you want to type it, you could do that too.
Yeah, maybe he hit by mistake, I guess.
Oh, okay.
Could be.
Dr. Moizuddin, do you have any questions? I see. Well, Syed, this was really, really helpful. I think this was a really good primer on, what we should be doing. Some people might be ahead in the process and might have already done this, but I know a lot of physicians have not. And, we have physicians who are still in training or just starting their career. So this is really helpful for them. And, like you said, this is hopefully the first of several webinars that we do in the future.
Sure.
And if people need to get in touch with you, how do they do that?
Yeah, I put my phone number there and my email address there. They can always go to the website, is on the screen. For DAANA members, they can call us. It's all pro bono in terms of the consultation. You don't have to pay us anything. In terms of giving, advice is what they need. But the whole idea is to talk about the importance of financial planning, just to get a gist of it. And they can call us anytime if they have any question.
Can you hear me, Nishat?
I do.
Yeah, okay. So I had one more question. Like some of alumni have already had their wills and trust made by different lawyers at some stage of time in their life. So if they want to seek consultation and maybe update it or maybe make changes because their assets have changed or something, would you be helping them to?
Absolutely. So that's what we're here for. So that's why every 5 years you should always take a look. Like the Secure Act, as I mentioned, that's a major thing in estate planning, and that needs to be incorporated into the trust. A lot of clients are doing it. So absolutely, we'll be more than happy to take a look at existing will and trust and give them suggestion what changes needs to be made.
So I think we have one more question. Dr. Atiq Khan is asking, once you make the will and trust, where do you keep it?
Yeah, you have one option to keep it with the lawyer. A lot of clients do it. Or we recommend ideally to get the original copy back from the lawyer, put it into the safe place. The main problem is that at one point we will need the original copy of the revocable trust. So if you're not 100% safe, lawyer is a good idea maybe. But the problem we see with the lawyer, what if the lawyer's office shut down? So that's why I think home is a safe place. And we always recommend you keep a copy, give it to your financial advisor. Hopefully you have someone you can count on, you can trust on, and upload it into some sort of like online secure deposit as well. We always recommend doing that. And then obviously, just in case if you lose it, we just have to go back and restate everything. But yes, make sure you let few people know where the original copy is located. That's very important.
Yeah.
So can you have like 2 copies originally signed and keep one with you and keep one with trusted person? If case you lose one, you have another one. Is that no, or you only need 1 copy?
You just need 1 copy, but because what happened if you have 2 original signature,
That can
that
create
becomes create a complication. But usually we see 1 copy either with the attorney or either with most of my clients actually have it home in a safe box, and they let their children know if anything happened, what to do, including the financial advisor.
Yeah. I think everyone should have one of those fireproof safes in their
Yeah,
house, and
correct.
put important documents in. That's what we do.
Correct.
Let me see.
Nishat, thank you. This was very, very, we think that we know a lot of things, but if, listening to you, it looks like I'm back in kindergarten, trying to understand everything about ABC, about trust and bills, Thank you.
Yeah, I really appreciate your, you're coming in a short notice, and we try to make it not too complicated. Hopefully, it makes sense. But the recording will be available for people to see.
Yeah, we'll make the recording available.
So if any more alumni are not asking questions, I think we can, call up for today, and we look forward to working with you, Nishat. And I think a lot of alumni will have a lot more questions, and we're looking forward to, we will share your email address and, contact phone numbers with all our alumni, even those alumni who are not in the conference today, or they were unable to attend because of any, professional or personal issue. So they can, get in touch with you as well. Thank you.
Absolutely.
Have a
I'll
nice
send the
day.
recording as well. All right. Thank you for your time. Really appreciate it.
I also
Thank you.
want to mention that Syed will be live at the reunion, right, in Chicago.
Yes, inshallah, I'll be there.
So
we are looking forward to meet you in person. Thank you.
We're looking forward to long-term relationship with DAANA. Absolutely.
Thank you so much.
Right. Thank you.
Good night, everyone. Thank
All
you.
right. Good night. Bye-bye.
Assalamu alaikum.
Assalamu alaikum. Bye-bye.